thank you for joining us for this extended breaking news coverage of the report looking into last winter's use of the Emergencies Act. We, of course, are watching for all reaction to Justice Paul Rouleau's report. Later this afternoon, we will hear from the Prime Minister, Justin Trudeau, set to speak at 3 p.m. Eastern Time. We, of course, will take you live there. Also, Conservative leader Pierre Poilievre will speak right after that. And we do expect to hear from NDP leader Jagmeet Singh in the near future. So, of course, we'll have that all covered for you. But this is just breaking. Just moments ago, the Commissioner of the Public Order Emergency Commission, Paul Rouleau, delivered the report's key findings. Take a listen.
After careful reflection, I have concluded that the very high threshold required for the invocation of the Act was met. In particular, for reasons that I discuss in detail in the report, I have concluded that when the decision was made to invoke the Act on February 14th, 2022, Cabinet had reasonable grounds to believe that there existed a national emergency arising from threats to the security of Canada that necessitated the taking of special temporary measures. I do not come to this conclusion easily, as I do not consider the factual basis for it to be overwhelming. Reasonable and informed people could reach a different conclusion than the one I have arrived at.
Okay. Hello, gang. I know everybody is just digging in there. There we have, of course, helping with our coverage today, the new host of Power and Politics, David Cochrane, and as well, senior reporter Janice McGregor. They've both been digging into this report. 2,000 pages, 5 volumes. That's why you saw their head down when we came to them, because they are still digging into this. So, Janice, let me start with you. You're down in the lockup. So that's where people get to see this ahead of time, to read some of this massive report. So start to break it down for myself and for viewers.
Yeah, I think it's important to sort of see what he has found in this report in a bigger context. He placed it in a historical context. Some of his criticisms of government are for the failure to anticipate that coming out of pandemic, he talked about how this is something they've seen with earlier pandemics. You could expect a certain amount of civil unrest. And one of his kind of very general critiques is that, look, you should have anticipated something like this happening. But on the specific kind of legal stuff, I was really listening to his remarks just a few minutes ago to see what he would say in terms of other things we know are before the courts right now, the official kind of challenge to the government's invocation brought by civil liberties groups. I think it's really important to understand that when he says in this report that he finds that it was sort of appropriate for the government to invoke the Act, this is not binding on the finding of any other courts. That's not what this process was. It's based on his own views, his own assessments. And he also said, and I think this is also important to understand in the spirit of sort of recognizing that a lot of very passionate, even divisive arguments were brought forward as part of this process. He says he didn't consider the facts to be overwhelming in this case. Reasonable people could arrive at a different conclusion. It'll be interesting as reaction unfolds this afternoon to see the extent to which people who disagree fundamentally with where he landed kind of cling to those statements and want to capitalize on them as saying it isn't self-evident that there aren't things to criticize the Trudeau government for in all of this. I think the other thing I just will take note of is that a lot of kind of when you tuck into the 56 recommendations, some of the most valuable stuff, the stuff that will live on and become action to-do lists for the Trudeau government going forward, have to do with the legislation itself. He has a lot of suggestions about how to improve the Emergencies Act, how to make it more fit for the times, how intelligence agencies should adopt and become more fit for the times, and why this process wasn't as good as it could have been in terms of transparency, in terms of documentation. He notes that the Order in Council was written without consultation. And in the future, if you're going to appoint someone to run an inquiry like this, they should be brought in to the wording of sort of that mandate given. So there is a lot here. We continue to tuck into it. Yeah.
Yeah, sorry, just on that point, because I know you're going to get to some other failures. I just want to continue on that theme just for a second. We're going to keep going, so there's a lot to dig into. One thing about the Emergencies Act is that this was a law that was passed in 1988. It had never been used. It had never been revised. Correct. And something that Justice Rouleau said in his press conference shortly ago, or judicially interpreted. So this is the first time, really, that, the Rouleau report is the first draft on history of this act.
Correct. Yeah, absolutely. And I took note, and when people kind of get to the report, and if you're watching at home and you need a bit of a reading guide, I can tell you, go straight to the first volume. And no, I'm totally serious, because I know people do this. Page 247 is the part where you want to tuck in, okay? Because these are the main parts. But he really talks about this as being, a singular moment in history. He said, though extraordinary, this was not entirely unpredictable. And he, I think, is very self-aware in this report that he is the first guy to kind of take a crack at interpreting this, that he had no precedents to work from, no other kind of learned judgments, that sort of everybody was working through this in really unprecedented, uncharted sort of times here. So, again, it's come back to what I was saying at the beginning, for context, right? But going forward, there are specific changes, not just to federal legislation, but to Ontario's Police Act as well, that he sees as necessary, coming out of the things we talked about, sort of the disagreements between police jurisdictions, the need to do better on that. The issue of police interference, there is a really interesting recommendation here about having clear guidelines for not only when politicians are allowed to ask for information from the police, but what information police should proactively be giving back to politicians. Of course, that harkens to the issue with Brenda Lucki, whether she should have spoken up at that key cabinet meeting. The other thing I'll say quickly is, anyone reading through this, looking to see if there's a fall guy, this report is, I should say, I think, kind of generous so far in terms of key policing figures, like former Ottawa Police Chief Peter Slowly, the RCMP head Brenda Lucki. It's quite balanced in terms of its assessment. There are some pointy criticisms about Peter Slowly, particularly his use of Navigator, that communications consulting firm, those contracts that came up, that they were perhaps crossing the line, starting to interfere with police operations in a way that wasn't appropriate, but also saying clearly that this wasn't just his fault. And likewise, with that moment where Brenda Lucki didn't speak up in cabinet, he concludes that he's not sure that would have made a difference to the final decision taken by the Trudeau government. These little moments, those little lines in the report, I think deserve a lot more kind of thoughtful kind of processing, if you will, than we've been able to do so far in just this quick lockup.
Okay, Janice, don't go anywhere. I want you to dig into some more of those thoughtful little moments in a minute, because we're not letting you go. There's so much to dig into. So let's go to the host of Power and Politics, David Cochrane, who joins us as well. Now, David, I want to point out something else that Justice Rouleau said in his statement as well. And it was something that the Prime Minister testified to, that these protesters didn't want to be heard, they wanted to be obeyed. And he went through a lot about the protesters. Maybe you can take us through that part of it.
I think, Hannah, I think it'd be useful to go through, I think, a tick-top of a lot of key points here and sort of high-level thematically spell out what I think this report tells us. I mean, the headline is that the government cleared the bar in the use of the Emergencies Act. This is the central question to this entire inquiry. If you are going to use these extraordinary emergency powers, this inquiry is the baked-in accountability mechanism to assess the information you had at the time, measure that against the tools that were available to you and the facts on the ground, and render a verdict as to whether or not the high threshold was met. That is the central point of this inquiry. And Justice Rouleau, he says it's not a slam dunk, but he says they cleared the very high bar. This is not a standard like a criminal trial where it's beyond a reasonable doubt. It's more akin to a civil trial where it's balance of probabilities. And he has made it very clear in his assessment of the evidence that was presented over weeks of testimony and written submissions that the government met that bar. He concludes in his findings that the protests in Ottawa were not lawful and they were not peaceful. He concedes that most of the people who were here and at other parts across the country were lawful and peaceful, but there were elements in there and with no ability by the nominal leadership to control it. And in fact, he says that they were more aware of it than they perhaps testified and took little action to deal with some of the more extreme elements and were completely unable to deal with them. So the protests were not lawful, they were not peaceful. Money was flowing into them, necessitating the measures in the Emergencies Act. The argument and the criticism that was leveled at the government that they should have met with the leadership of this. They should have tried to negotiate some sort of a departure from Ottawa without resorting to police enforcement. Justice Rouleau makes clear that that was not a viable option, that there was no centralized leadership, no ability to control the thousands of people who were here and at other border crossings and other protests across the country and in sympathy protests across the country. There was no central organization to sit down and negotiate with, so he dismisses that central argument. He points out that extremist groups like Diagolon, that Jeremy McKenzie testified this was all just a joke. He was the founder of Diagolon and is now facing criminal charges, another matter. He makes the point that they were present in Ottawa, they were present in Coutts. They were coordinating back and forth, even if the larger protests were not. And the arrests that the RCMP made in Coutts and the sort of the extremist language around this organization justified the concerns of the RCMP. He's very critical of the Ottawa Police Services and the Ontario government. A cascading failure of intelligence and police failures and planning failures by Ottawa police that underestimated grossly what was coming to Ottawa and then had no ability to deal with it once it got here. Breakdowns in communication, constant change of command, a mistrust at the command levels inside Ottawa Police and between Ottawa Police and the other police forces who were brought in. Again, a narrative, a manifest display throughout the commission every day in the testimony. And he also criticizes the Ontario absence, the Ontario government absence in dealing with the situation here in Ottawa, calling it troubling and making the point that Ottawa sent a very clear message to the people of Ottawa that they had largely been abandoned by refusing to participate in the three-level meetings between the City of Ottawa, the federal government, and the provincial government. The provincial government simply didn't show up. Ottawa is a municipality in the province of Ontario, governed by Ontario legislation, and it necessitated a response from the Ontario government. Janice just mentioned this. Yeah. This notion of there might have been a policing plan on the 13th of February, the day before the Emergencies Act was invoked, that could have led to a police resolution to the occupation of Ottawa within the existing powers that existed. He dismisses that. Brenda Lucki never brought it up. She never spoke publicly. She's been criticized for this. Justice Rouleau says it wouldn't have mattered if she did. There were still so many issues to be resolved in the plan, so many things to be sorted out, that at this point in the decision-making process, it was irrelevant to whether the Emergencies Act was going to be invoked or not. The same thing for the consultation with the premiers the very next day. This has been criticized by some provinces as falling short on the need to consult, that the premiers felt they didn't have enough time. Some of the premiers felt that way, and they felt that the Prime Minister had already made up his mind. Justice Rouleau concludes, he finds that this met the threshold. And while he has some criticism for some of the measures that the government used to deal with the protests, he says they were largely reasonable and effective, such as to apply protest limits to areas, to ban on travel to protests, to give money to protests. There's criticism for freezing of accounts because it captured people who needed to give money to other people. There's no way to get off the list once you left the protest area and get your accounts unfrozen. But on the big picture question, for the government of Canada today, for the Trudeau government, this is about as good as they could hope for, given the action they had to take to deal with the situation that they were dealing with a year ago. And Rouleau says that they largely cleared the bar, their actions worked, and they were, for the most part, effective and limited and measured.
David, I know you have to go do other things too, but I want to ask you one more thing before you go, and then we're coming back to Janice too, because I want some of those highlights. Janice, I see you there waiting for me as well. One of the things Rouleau said, people called this a protest. In particular, a lot of people who were involved in it. But one thing Justice Rouleau did say in his press conference is that this protest turned into a mass occupation of the nation's capital. So again, kind of tamping down what many people said, that this was friendly, this was fun, this was like Canada Day extended. There you see it there, only a year ago. What are your thoughts on that, David?
Look, Justice Rouleau is charitable and kind to the protesters in many ways in this report, saying that many of them were law-abiding and honest Canadian citizens who felt aggrieved by vaccine mandates and vaccine policies, and they were greatly affected by this. But so was everybody in Canada. And what he made, his analysis of what this turned into was a lawless and unpeaceful occupation of the city. Now, anyone who was here, that was very clear. If you lived in the downtown, that was very clear. That was obvious. That's why injunctions were granted. That's why civil cases are happening right now. And that's why eventually there was some enforcement action that took place. He points out that this whole thing started because the trucker vaccine mandate imposed by the cross-border trucker vaccine mandate imposed by the Trudeau government became a rallying cry for truckers who were already struggling to deal with the restrictions of the pandemic and had capacity to organize and familiarity with logistics. He also points out that the United States brought in a vaccine mandate for cross-border trucking before Canada did. So whether the federal government brought this in, they still would have had issues there. And there is criticism for the Prime Minister. That comment he made about a small group of people with unacceptable views that has been seized upon as a galvanizing quote by critics of the Prime Minister. He said that certainly helped inflame the situation. And he makes the point that politicians and the media could have been more tempered and more measured in their commentary about people who were protesting their legitimate grievances or their frustration with health restrictions and vaccine mandates that were being imposed not just by the federal government, by governments at all levels. But he also makes the point that the Prime Minister's comments that have been seized upon were also taken largely out of context by political actors, protesters, and by the media. But it's pretty clear, Justice Rouleau says that the series of failures along the way led to a situation that the government was right to believe. There's page 247 that Janice told you about, Hannah, but also
I'm writing them down.
But also page 210.
Okay.
You know, where he says he says there was an objective basis for Cabinet's belief based on compelling and credible information that what was required, that the standard of reasonable grounds were met here, that the threshold for invocation is the point at which order breaks down and freedom cannot be secured or is seriously threatened. And he says, in my view, that threshold was reached here.
Okay.
Those are not insignificant comments from a judge of his stature.